Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us, which I think is a very important book for those about to embark on a fairly substantial legal career, and for older people like myself who've got to try to come to grips with some of the big changes that are taking place as I speak with the use of the digital systems that we now have in place, information technology, whatever you want to actually call it. We've got some changes happening, and I've reviewed in the past a number of books by an excellent author called Stephen Mason. Now, Stephen has come up this time with a book on electronic disclosure. It's got a subtitle, A Casebook for Civil and Criminal Practitioners, and it's been published by PP Publishing. That's Peer Press. Elizabeth and I, Peer Practice I think it's actually called. Now, my wife Elizabeth and I had a talk about this book, and we, for our review, came up with the title, a brilliant 21st century short statement from Stephen Mason on where we are today with the legality of e-disclosure in the digital age. Now, before I go into the review, let's have a look at the book. It's a hardback, very small book. See, there's the front, spine, and then the back. I rather like the front visual, the actual magnifying glass and the computer. Let's go to the front of the book. There's the first page. You see there where we are. Then there's an acknowledgement, which is quite important, about a hyperlink for the electronic edition. This is available as an ebook as well, and you've got all of the details there as to how to get into it if you're familiar with that side of things. Then there's an important introduction with various reference points, and then we go into the contents. It starts with a table of cases, then there are the standard statutes, rules, etc. Then we get into the various chapters, and then there's an appendix right at the back, which is just here. You can see some of the particular reference material that is used. Then finally you've got a short index at the back. It's not a big book. It runs to 150 pages at probably the most. There's the actual general information about the at the back concerning the useful information about this area of law, which is not the easiest for many people to understand. And if we open it up in the middle, you can see a lot of case law. This is about case law because it's about looking. In fact, this case here is a very important one. It's the Andrew Mitchell case, which features very heavily in a lot of the literature we have today. Then, of course, he starts off at chapter 1, the introduction. The narrow aim of this book is to provide a practical guide to electronic disclosure, or e-disclosure. That's what he produces, and that's what he does. Now, I'm going to call it e-disclosure because it's the easiest shorthand for it. But as probably many of you will know, Mason is someone who is known to many of us for the excellent work he's done in this developing area of law. As we look at tomorrow's lawyers, to coin someone else's expression, as to what we're going to be doing in, say, 15 to 20 years concerning the way we approach the subject and how we actually get information we want. So this is what we say about the book. The concept and procedure of what is called e-disclosure has become a most important device for all practicing lawyers in England and Wales. We've reviewed, as I say, a number of Stephen Mason's previous books which have maintained a consistently high standard when explaining the intricacies of the electronic methods of disclosing material. And it makes it so much easier for us all to actually understand all this stuff, because frankly I did find it very complicated initially, and I know a lot of other people did too. Mason rightly says that e-disclosure, quote, is now the everyday fare of all practicing lawyers, as are electronic evidence and electronic signatures, because the legal profession has firmly entered the digital age. Advisors need therefore to understand the extent of the complex changes which have taken place, because litigation and e-disclosure now go hand in hand, and advocates, I think, should take note of that. So barristers and solicitors who act in contentious business need to know how the courts and the judiciary are dealing with the problems that electronic disclosure throws up. And as Mason says, the judges have now taken up the challenge guidance and rules relating to e-disclosure were set up some years ago, but as the cases show, many lawyers remain blissfully unaware of three important topics, namely e-disclosure, e-evidence and e-signatures. I certainly have had to make a specific effort to get much more up to date and up to speed in this area, and I'm grateful to have this book as one of a number now available to explain to me where we're going with it. Electronic Disclosures, then, the book, does not purport to be a comprehensive statement. It isn't, but we found it highly readable and simple to follow. This whole digital area is one of worry and misunderstanding to many practitioners concerned about how to respond to the practical challenges discovered by firms in meeting the electronic disclosure protocol. Because as usual we have some sort of guidance as to how we're going to go about all of this. And of course we really would be in the dark otherwise without having it. Hopefully you're advised by the author to look at the e-disclosure protocol pack and the guidelines which have been prepared by a number of organisations. TCSA, I'm not quite sure what that is, Tech Bar and the Society of Computers and Law, and there's a reference which he gives in the book which is small v 0.2 dated the 9th of January 2015, and that obviously is the standard version that's available. Again, as I say, we're in a new era for this, and I'm learning, like everybody else, how to use this in the future, because I can see a time coming very shortly where the crunch will be upon us and we're going to have to know exactly what we're doing, and that is getting imminent, I think. Mason adds that the protocol pack is particularly relevant to proceedings in the technology and construction court, and is apparently also being used in other divisions and in arbitrations. So it's probably fair to say that we've only just started down the main e-disclosure road at the moment, as I record this in the middle of 2015. Yes, there is no doubt, in fact, of the usefulness of this concise guide. The author's intention is to offer the book as an aid to both lawyers and their technical advisors working on e-disclosure in England and Wales, in the England and Wales jurisdiction, and he does just that. What we found particularly helpful for advocates is that Mason gives us an indication of how judges have approached the issues arising in both civil and criminal proceedings, by the use, of course, of a substantial amount of case law. His conclusion, which we heartily agree with, is that the guide is of interest to all jurisdictions struggling with the same issues. It certainly is. Thank you, Stephen, very much indeed. Let's just have another quick look at the book. There it is again. Gold cover, spine, and then you've got the back there. Quite a bit of detail, some of which I've mentioned in the review. And if we go into the book itself, we're looking at metadata here. And there's a practice direction again, which refers to the disclosure of metadata and what it actually is. It's data about data, if I can put it that way. Then you've got keywords and searches, all this stuff that we're getting used to now. Date ranges rather, dealing with carrying out a particular search of a particular time. I've always maintained that it's quite important to have a timeline of exactly where you are with a lot of information. Obtaining disclosure from third parties, another important area, I think, again, in the litigation arena. Pre-action disclosure, I think, would be relevant to quite a lot of solicitors as well, bearing in mind that that is very much the litigation side before counsel become involved. I'm very impressed with this book. I think it's a great addition to where we are at the moment. It is fundamentally a case book, but I'm sure that this is going to build up as we get more case law and as we see the changes with IT that are going to take place. It's quite clear with the reshaping of civil justice in particular, and criminal justice probably over a slower period, that we are going to have to rely very much more on this sort of approach. And I, for one, actually think I'm a main supporter of it. I know there are some people who would ideally like to go back a bit and say, well, do we really need to go down this route? But I think we do. The fact is we are anyway. So thank you very much to all concerned for an excellent publication. And good luck with any new editions too. Bye-bye.